Court is calling 2024 CR 5966, State of Texas versus Jimmy Cardell Claiborne. Can I have parties announced for the record for the state? Defense. All
Rolando Ruiz for the defense.
right. Are you Mr. Claiborne?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Claiborne, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it? And did you sign it? Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented? Did you review the document entitled Court Admonishments with your attorney? Did you understand it? And did you sign it in all the appropriate places? Did you understand you're charged with the offense of credit or debit card abuse as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? You're gonna need to speak up.
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, he is.
Mr. Claiborne, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
I'm not.
Anyone promised you anything other than the plea? Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $500 fine. State recommends deferred adjudication, and there's to be restitution to the complainant. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 3 years. There be a TAP evaluation, 60 hours of community service restitution, and the theft course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
No.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
No objections, Your Honor, for purpose of the plea.
Okay. And state, you may be excused. Counsel, Mr. Claiborne, did you review what's entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same.
Rolando Ruiz. Rolando Arguelles. Arguelles. First name Rolando.
All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
But the court just followed the agreement that we have with the state.
All right, why are you stealing?
It was in a bad spot at the time.
No, I mean, I don't understand why when people think they're in the bad stop, the go-to is let me steal from somebody else who's been working hard. So why are you doing it? And what bad spot are you talking about you're in?
Wasn't doing it, it was one time.
No, I mean, one time is too many. So what bad spot were you in? Because you're employed. So what bad spot were you in that you would take somebody else's credit card and use it?
I had just started working, I needed Pampers.
So, I mean, see, that is zero excuse. Let me tell you why. Because there are plenty of places that will give you free Pampers. And guess what? I don't know why people are stuck on this Pampers thing, because if you can't afford Pampers, you know what you do? You use cloth. Pampers is just something that's been brought in new to existence for convenience. But back in the day, people would use cloth diapers. You get cloth diapers, and guess what you do? You wash them and they can be used again. So, again, what were you buying at Walmart?
Gift card, I didn't want to keep using the card.
So you use their bank card to buy a gift card for yourself to use.
It's not,
All right, so you didn't want to keep using their card because you didn't want to get caught.
it's not.
So don't act as though you were doing them a favor by, oh, I'm going to Walmart to purchase a gift card. Anything you want to say for your client?
We are, due to the nature of the circumstances, we are asking this court to defer the finding of guilt and give him the opportunity. He's remorseful about his actions. It was a one-time occasion. He's not a convicted felon. So therefore, we're asking this court to give him that one opportunity to keep up the felony conviction, be a better parent, better husband.
All right, I know he's saying it was a one-time thing, but according to the police report, they're not saying it's a one-time thing. Because it states the credit card companies contacted him and his wife regarding suspicious charges. There's an S on that. So that means there was more than one charge. Otherwise, they would have said regarding a suspicious charge.
I understand that, Your Honor, but I mean, police reports at this moment, the only thing that was mentioned was the $501 that Walmart tried to say. There wasn't anything else alleged.
Well, there's a situation where he tried to use the card for $100. That's what's in the police report. So you have the $500 Walmart, and then you have another $100. How many times were you trying to use their cards? Or how many times did you use their
I
card?
only used the card one time.
It says, Mr. Vincent advised the complainant that on August 7th, a $100 charge was attempted at the Walmart with the Bank of America card. And then the second and third attempts were at the same location at approximately 6:45 a.m. and 6:46 a.m. The second charge was $504 with an American Express card. And then there was a third attempt for $204. So there are three.
Well, Judge, we're still asking this court to follow the state's agreement at this point. Like I said, my client is remorseful of his actions. He's not intending on doing so again. He's not a convicted felon and would like to keep that a felony conviction off his record, to be a good father, get secure employment, and be able to provide for his family.
How many children do you have?
Four.
I'm sorry?
Four,
What are their ages?
11, 7, and 2 1-year-olds.
And who do you live with?
My fiance,
Is this your fiance? You put a ring on her finger, y'all are gonna get married? Or is this somebody you just live with for a while and y'all decide to say she's the fiance?
no ma'am, I've been with her for 6 years. I put a ring on the finger.
All right. And what does she do for a living?
Right now she works from home.
Doing what?
I don't know, she just got the job when I got locked up. I think it's for AT&T.
And how far did you go in school?
Now,
How far did you go in school?
we have associates,
Associates in what?
business.
And what have you been doing with your associate's degree?
Well, I just moved to Louisiana. My uncle was gonna help me open a business for myself.
All right, so are you in Louisiana or are you in Bexar County?
I just moved to Louisiana in December.
Oh, so is he gonna be living in Louisiana?
We are going to be asking probation. I explained to him that it can be transferred, but it has to be through the probation department. He first needs to check in here, and then probation arranges for that to happen and be able to move to whichever parish that he's gonna be living in Louisiana.
All right, and your fiance is in Louisiana?
Yes, ma'am.
What parish?
Saint Sam.
All right, this is what the court is gonna do, is a $500 fine. The court is gonna sentence you to 4 years deferred adjudication. There's to be restitution to the complainant. There's to be proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. 120 hours of community service restitution. The court will waive 60 of those hours upon completion of parenting classes. And the court is ordering parenting classes. There's to be regular UAs, regular reporting by Zoom or in person. I'll do a transfer to St. Tammany Parish. And the theft course. Probation, is there anything else he needs? I'm sorry, well, I'll order field visits, but he's trying to transfer to Louisiana. But while he's in San Antonio, then there'll be field visits 1 time per month until transfer. Is there anything else, probation?
No.
Is there anything else you need from the court to be successful? Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. Stealing is never the answer. You understand?
Yes, ma'am.
There's a lot of free places, at least in Bexar County, where you can get diapers, you can get on WIC, you can get help with food. They have all these pantries available. So that's not the answer. Now, let me just tell you, with this offense, whether you're on deferred or not, it's considered a crime of moral turpitude. So what that means is your business degree, maybe you'll be able to do something with that, maybe not. Your attorney can explain to you all of the collateral consequences from pleading, and I know he probably did already explain to you the collateral consequences from pleading to any crimes that are considered crimes of moral turpitude. You understand? All right, good luck to you. Thank you,
Thank
counsel.
you, Judge.
All right. All right, court is going to go on the record. Court is calling night mag number 753-623, 753-624, State of Texas versus Ray De La Rosa. That party is announced for the record for the state.
Zach Dunn for the state, Your Honor.
Attorney John Garcia for response for defendant, Your Honor.
All right, and are you Ray De La Rosa?
Yes, ma'am.
All right, the court is in receipt of a third motion to modify terms of bond release. State, have you had a chance to review the defense's motion?
Yes, and defense and I spoke, Your Honor.
All right, and state, are you ready to proceed?
Yes, state's ready, Your Honor.
State, are you in agreement with the motion?
No, Your Honor.
All right, defense, do you have any witnesses?
Yes, we do, Your Honor. We have Mr. De La Rosa's wife.
All right, Mr. De La Rosa, if you move over to the side, can you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, lower your hand. You're gonna need to keep your voice up so that the court reporter can hear and so that I can hear.
Okay.
If you do not speak up, then your testimony is for naught because I cannot hear you. Do you understand?
Yes.
All right, state your name for the record.
Herlinda Corte,
All right, and spell your name, please.
HERLINDA ALCORTA.
All right, everyone, we're on the record. You need to whisper. Defense, your witness.
Yes, okay, you're the complainant in the 2 cases against your husband that we're asking for a bond modification for no to be changed from no contact to no harmful or injurious contact, correct?
Yes, sir.
Okay, and you feel that affidavit's a non-prosecution in both those cases?
Yes, sir.
Okay, and you have no problem with that motion being approved by the judge, correct?
No, sir.
I'll pass the witness, Your Honor.
Just one clarification question. Ma'am, you came by the fifth floor of the Cadena Reef Center to drop off the aforementioned affidavit of non-prosecution, correct?
Yes, sir.
And you told the person at the front window that you were with your brother, correct?
Yes, sir.
Okay, but does your brother have a similar Jesus tattoo on his
No.
left arm?
Well, my brothers have tattoos. They
Does he
all-
have a Jesus tattoo on his left arm?
My brothers have
Your
Jesus,
Honor,
but they have Jesus on. They have bottom and top.
So my final question is, did you show up with the defendant or did you show up with your brother?
No, with my brother. I have not seen Mr. Ray de la Rosa since last year.
No further questions.
All right, any other questions?
no, Your Honor.
All right, thank you.
Yes.
Defense, Mr. Delores, you can say, it. Any other witnesses?
Nothing from the state, Your Honor.
Nothing from defendant, Your Honor.
All right. State, you're
Yes, Your Honor.
opposed?
I apologize, Your Honor.
You're opposed?
Yes, Your Honor, we are opposed.
All right, for
You're-
what reason?
We have good reason to believe that they actually showed up together to drop off the AMP, which is of course a violation of the no contact order. And I think the state's position is clear only in that when you're awaiting 5 indictments and 6 cases total, we believe that just in the best interest of community safety, to not lift this, Your Honor, so that is why the state's opposed.
All right, defense,
Your Honor, my client has been following the bond conditions. He hasn't had any problems for the last 5.5 months. His wife has filed 2 affidavits of non-prosecution. She has no problem with the modification being changed from no contact to no harmful or injurious contact. My client is an older person and his spouse is an older person. They would like to be together.
how old is your client?
60.
Okay, that's not old.
I don't feel it's old. Now that you say it, I don't
yeah.
feel it's old. But we're asking if you could please allow for that bond modification, Your Honor.
All right, so here's my question. He has 2 cases before the court. Nightmag number 753623. What is the charge in that case?
So fortunately, the system only pulls up the grand jury numbers, Your Honor, so I have to click into each one. I apologize.
No problem.
There's a myriad of assault seconds, so I'm gonna,
Well,
Just some.
this is what I want clarification on. The 2 cases that he's before the court now, asking that he be allowed contact with his spouse. Are those assault family second cases?
is one, go ahead, go ahead, counsel.
Go ahead, go ahead.
Is one of them 753623?
Yes.
That's an assault second.
And the other is 753624.
753624, Your Honor, is a violation of protective order assault stop.
All right, so now this is my next question. In each of those cases, who is the complainant? I'm assuming the complainant and the cause number ending in 23 is his wife?
Yes, Your Honor.
And who is the complainant and the cause number ending in 24?
There's Linda as well.
His wife?
His wife is his spouse as well, Your Honor.
All right. So your motion is denied. Is there anything else?
Yeah. Does the district attorney have a time frame about when the cases will be invited or?
Oh, you'll have to speak to them about that. All right, your motion is denied. Is there anything else?
Nothing present from the court, Your Honor.
All right. We can go off the record. So, Mr. De La Rosa, you have 2 cases. In both of the cases, your wife is the complainant.
She's not the one that complained, it was her sister. Her
Mhm.
sister's the one that complained, she's the one that called out a person. I wasn't even present.
Well, maybe your sister, well, here's the thing. Maybe your sister-in-law will come down and testify.
I hope she does.
Yes. All right, thank you.
Thank you,
Thank
Judge.
you, Your Honor.
You're welcome. All right, Deputy Laura on Guadalupe Espinoza. Can you let her know her attorney is ill?
Yes.
And so we're gonna recall this, Norma, recall it for 2 weeks.
Yes.
And if you'll let her know if her attorney is able to come in sooner, we'll have her brought over sooner.
I can do July 9th.
All right, so let her know, recall her for July 9th. What page is she on?
She's on the first page, Judge.
All right, thank you. All right, Lucy Rodriguez. Good morning. Hello.
Good morning.
Morning. All right, so where are we on this case?
So state could not find the file for this case with the advocate. Our advocate's out this week. I asked another advocate to look for the file and they just got back to me that they could not find this. So I apologize. I'm not sure administratively what's happening here. Either way, even if we were able to find the file, Your Honor, I am unsure if we have the CPS records for this case. And I say that because today's my first day looking at this case. However,
Mhm.
when I looked at the records, that the printout that I saw that I reviewed with, or that I showed to counsel, there's a DA upload or a scan from 2023,
Okay,
so a whole year ago. And then I just looked through the file right now and there's no discs in there.
Okay.
So I'm a little confused and it's with an investigator that's not ours. So I guess the bottom line is, one, I need to find the file for Lucy. And
Mhm.
two, I need to confirm that if we have CPS records for both Lucy and with Yukio.
all right. All right, Ms. Ferguson, on this case, give me a reset date for 30 days.
Yes, ma'am.
And could I see the file on Rafael Rodriguez? Are you here for Rodriguez?
I am, Your Honor.
Okay.
Wearing a lot of hats today.
Okay,
I can do July 29th.
all right. Are you employed?
No.
All right. All right, so we'll come back on July 29th to see where we are on discovery.
Thank you, Judge.
Thank you, Judge.
We're on it.
All right, thank you.
In which case is this, Judge?
This is Lucy Rodriguez on page 6. All right, if you'll have a seat.
Okay.
All right, Refugio Rodriguez. All right, and is it the same announcement on this case as well?
Same exact announcement, Your Honor. Yes. We have the file for this, but in either event, Your Honor, I'm gonna check on CPS today.
All right. All right, on this case, we were here for CPS records in May, so this will be the last setting for everybody to see where the CPS records are. All right, so we'll come back on July 29th. Thank you.
Thank you, Judge.
All right, you're welcome. All right, everyone, if you have not had contact with your attorney, we're starting a jury trial at 11. So if you want to step outside, call your attorney and tell them to be here, then you're more than welcome to do so. Okay, I thought I saw Aaron and James. Were they called upstairs? No, not necessarily. I think they were sitting over in the corner, but I allow everybody to drop in and drop out because I want them to get a global experience of being in the criminal law field. But we have a court reporter here today and she is doing real time, which I will tell you, since you want to be a court reporter, a lot of judges want court reporters to be able to do real time. So with real time, I'm able to see everything that she's putting in her system, of course, in a language that I can understand. And I like it because sometimes attorneys are whispering and it's hard to hear. And then sometimes I'm thinking, did I hear what I thought I heard? And so I'm able to look and see what she's heard because her record is the official record. So, yeah. So if you want to come around, you can come around and see what she's put in the system for me to view. So whenever you see things through my glasses, that's usually what it is. It's the real time. So when we had our hearings, she's been typing up. Yes. And so as you can see, she tells me, I'm not perfect, but I'm like, oh, here you are. So you can see everything that's being said. So we're back on the record in 2024 CR 2974, State versus Hector Casanova. All right, Mr. Casanova, here's the thing. And I want you to hear me clearly, right? I am not your attorney. The document that has been given you is a copy of the indictment. I'm not to give you information about your indictment. That's the indictment. That's what we're here for. So any questions that you would have about that indictment, you're going to have to answer those for yourself. Otherwise, the person who will be telling you about what the indictment means and what the numbers are, that will be an attorney. Do you understand?
I do not understand.
Oh, what that means is, for example, we can go off the record. I'm giving you a hypothetical. All right. Let's say you needed surgery and you're in the middle of the wilderness, you need surgery. And you tell me and you tell the doctor, guess what? I'm performing this surgery on my own. I don't need you. I'm walking out of the hospital. I'm going to go in the desert. Now, maybe the doctor would try to stop you and do other things. But if you go in that desert by yourself, don't tell the doctor where you are. You take a scalpel out in the desert by yourself. You don't get to call the doctor and say, hey, I'm in the middle of the desert performing surgery. I'm going to be my own anesthesiologist. I'm doing all of this. How do you do this? Because they're not going to tell you. It's the same thing here. You're saying that you do not want to be represented by an attorney. You want to represent yourself. So that motion, that indictment, I'm not to tell you anything about what that indictment is. The state is not to tell you, oh, this is what this indictment means. This is the range of punishment. Those are things that you're supposed to do. Do you understand?
I still don't understand.
All right. So just have a seat. This is what's going to end up happening. You're going to have an attorney. That attorney is going to come over to the court right now. You're going to speak to that attorney. After you speak to that attorney, we're going to go forward. Ms. Ferguson, can you call manage to sign counsel and let them know that we need an attorney over here? And that attorney will talk to you. That attorney will tell you what that indictment means. That attorney will tell you the range of punishment. Do you understand?
I still don't understand.
All right. Well, I don't know how I can further make you understand.
Are we on the record?
Yeah. All right, Norma, get someone from manage to sign counsel here, please. All right, just have a seat and we're going to have an attorney come down. All right.
I would like to ask some questions on the record, if I may, while I have your time here.
Oh, no, let me just tell you, you'll have my time till 5 o'clock because that's how long we're here. What is going to end up happening is an attorney from manage to sign counsel is going to come down. Do you understand?
I do not understand because I don't feel like I am needing an attorney because I'm here to represent myself as the flesh and breathing man, Hector Casanova Jr. Let's see. All right, so let the record of the court show that I, Hector Casanova
Just one
Jr.
second.
the accused
Just
in
one
the-
stop.
Yes, sorry.
All right, we're on the record. So what did you want the record to reflect?
So let the record of the court show that I, Hector Casanova Jr., the accused in this criminal action, has asked the court to divulge the nature and cause of the accusation upon the authority of the Sixth Amendment, and that this court has failed in its duty to inform me of the nature and cause of this action.
All right, and
Furthermore,
let me
let the
stop
record
you.
also show.
Mr. Casanova, let me ask you a question. Have you been given a copy of the indictment?
I believe so.
All right, so let the record reflect that Mr. Casanova has been given the copy of the indictment. And the copy of the indictment, it tells him what he is charged with. You may continue.
Now, these charges, are they civil? Is this a civil charge or a criminal charge?
All right, that is something that if you had an attorney to represent you, they would be able to tell you. What the court can tell you is that you are in a felony court and this is a criminal court.
Okay. So, this being a criminal, let the record of the court show that the action against me is criminal action. My following question would be, the Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under the admiralty or military tribunal. In which of these two jurisdictions does this court intend to try me?
All right, so this is what is going to happen, Mr. Casanova. Someone from manage to sign counsel is going to come over and you can speak with them or not speak with them. But the questions that you are asking the court are not, some of them are not in any shape, form, or fashion related to the fact that you're in a criminal district court. Do you understand?
I do not understand.
Okay,
But I don't think you'll be violating your oath of office if you did your duty under the Constitution. I am not seeking legal advice. What I want to know is legal intent.
Mhm.
I have the right to appear as myself in my own person without a licensed attorney. In order to intelligently defend myself, I need to know the jurisdiction this court is operating under.
Mhm.
Let's see. So therefore, will you please answer the question so that way this court is properly identified?
All right, you're in the 187 District Court. It's a criminal court. You're on the 4th floor.
Thank you. This constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under.
All right, I'm gonna
admiralty or military
Counsel,
tribunal.
I'm sorry, Mr. Casanova, in the human flesh. I'm gonna stop you right there. What is gonna end up happening, I want you to hear me clearly. An attorney is coming over for managed assigned counsel, period. That's it. So have a seat, managed assigned counsel will come over. Do you understand? Yes or no?
I do not understand.
All right, do you understand what it means to take a seat?
I do understand.
All right, so take a seat.
Yes, ma'am.
Thank you.
Of course.
Mr. Arguelles has been appointed to represent you. Have you had contact with your previous attorney?
One time I did have a video conference with him. It lasted about 2 minutes, ma'am.
All right, and how long ago has that been?
I'd say about a month and a half ago.
All right. And off the record, you asked the court to have another attorney appointed to represent you?
Yes, ma'am.
All right, and that attorney is Mr. Arguelles. Do you have any objections to Mr. Arguelles representing you?
No, ma'am, none whatsoever.
All right, and Mr. Arguelles, of course, you are entitled to 10 days. Are you waiving that?
We are, Your Honor, in the best interest of my client.
All right, Mr. Torres, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am, I did.
Are you the same Frank Daniel Torres who was placed on deferred adjudication in 2023 CR 7903 for the offense of assault, family, choking, strangulation on February 8, 2024 for a term of 5 years? Is that you?
Unfortunately, yes, ma'am, it is.
All right, state.
On or about the 16th day of May, 2024, in Bear County, Texas, the defendant, Frank Daniel Torres, did then and there fail to attend and successfully complete the following counseling education program, state accredited battering intervention and prevention program in violation of condition number 20.
How do you plead to that? True or not true?
True, ma'am.
State.
The state waives and abandons the others, Your Honor.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 20, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am, I do.
Knowing that, do you still wish to plead true to violation of condition number 20?
Yes, Your Honor.
Court will find violation of condition number 20 true. Is there a proposed agreement?
There is a proposal, Your Honor, yes.
And what is the proposed agreement?
The proposal, Your Honor, is for revocation and adjudication of guilt for then a term of probation to be 5 years and to continue on the conditions, notably because the complainant across both is the same. So that was the proposal with respect to conditions remaining the same, but this time with a conviction and a permanent finding and to be on straight probation as opposed to deferred.
All right, what I can tell parties, I'm not going to follow that agreement. If you all wish to continue on probation, the part of the agreement I'm not going to follow is the 5 years. So what would you all suggest for an underlining? Are you all suggesting for an underlying sentence with the conviction of 5 years?
Well, we want a term of 5 years of probation, correct, Judge? Unless the court wants to go lower, which we would not be opposed to.
No, I will not go lower.
I think the initial discussion was potentially for a 5/5, so 5 years, probated and suspended for 5 years. But if we need to increase the timeline, I'm happy to talk with counsel now.
All right, if you all can talk about that with the
Sure.
underlying.
Okay,
All right.
yeah, may we just briefly break away?
Yes.
We have an agreement, Judge.
All right, and what is the proposed agreement?
The proposal, Your Honor, would be for 8 years for the underlying and that would be probated and suspended for 5.
Correct.
All right. Are you asking the court to follow that agreement?
Myself, yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am, I am.
All right. This is what the court will do. The court is going to find you guilty. There's to be no contact with the complainant. The court is going to order partial GPS for employment only.
In regards to the no contact, Your Honor, can they have contact through one of the apps because they do have a child together, 14-month-old?
No,
How's he gonna take care of his child?
he's going to have to do that through some sort of, if they have custody arrangements.
That's what I meant, like through the apps that allow for that to happen, that they can have communication.
No, I mean, because, and you all didn't proceed on it, but I'm assuming the reason for this is because there's another allegation. And what is happening with that other allegation?
It's newer, Your Honor. It's from May, so I don't have any word from the intake attorney on the status of that case.
All right, and who is the alleged complainant?
Same complainant.
So no, I'm not going to allow that. So there's to be no contact with the complainant. There's GPS partial for employment only, and all other previous conditions are to remain. And I'll ask that GPS fees be waived. And I'm going to sentence you to 8 years in the prison, suspended and probated for 5 years. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. And also because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am, I do.
If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand?
Yes, ma'am, I do.
All right, we can go off the record. Here's the thing. There's no contact. I previously ordered no contact.
Yes, ma'am.
Obviously, it appears that it's not working.
I-
Yeah,
Yes,
and
ma'am.
I know that maybe the new allegation, you're saying it's not true, but I don't have any information for that yet, okay?
Yes, ma'am. Yes, ma'am.
All right, is there anything else?
Nothing from the state, Your Honor.
Nothing but the defense side.
All right, and is the complainant aware?
The complainant is aware of,
Court is calling 2018 CR 9930, State of Texas versus Fernando Serrato. Could I have parties announced for the record for the state, for the defense?
Joseph Appelt.
And are you Mr. Serrato?
Yes, ma'am.
Yes, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Fernando Serrato who was placed on deferred adjudication in 2018 CR 9930 for the offense of burglary of a habitation force on April 17, 2019 for a period of 8 years? Is that you?
Yes, ma'am.
State? Oh, and I'm sorry, also, did you review the state supplemental motion to enter adjudication of guilt and revoke community supervision?
Yes, ma'am.
All right, state, what allegations are you proceeding on?
Violation of condition number 13, Your Honor.
All right. Mr. Serrato, did you review violation number 13 with your attorney?
Yes, ma'am.
State is alleging that on or about the 11th day of February 2024 in Bexar County, Texas, the defendant Fernando Serrato did then and there operate a motor vehicle without a valid Texas driver's license in violation of condition number 13. How do you plead to that? True or not true?
True.
State, is that the only allegation you're proceeding on?
Waive and abandon the remainder, Your Honor.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 13, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 13?
Yes, ma'am.
Court will find violation of condition number 13 true. Is there proposed agreement?
There is not an agreement, Your Honor.
All right, state, what are you requesting?
Guilt supervision, adjudicate guilt, assess punishment for 4 years. Finding.
We would respectfully request the minimum, Your Honor, 2 years. And if I may, Mr. Serrato is not a citizen. He has been previously deported. After conferring with Justin Tullius at our last sighting on June 3rd, at length and in great detail regarding Mr. Serrato's situation, any possible defenses, et cetera. Mr. Tullius conferred with him, gave him certain bits of information and counseling advice. Mr. Serrato currently has a federal detainer on him for from ICE. And so what we're requesting, Your Honor, is to revoke him and sentence him a minimum 2 years. That way he would get transferred over to the Federal Department of Justice sooner and onto, in essence, their responsibility.
All right. Probation, has he done anything since he's been on probation?
No, Your Honor. Probation is recommending revocation. He was placed on probation April 17th of 2019, and he was transferred to ICE custody, and he was transferred to Honduras September 6th of 2019. We informed the court via supplemental report that he was deported, and February 11th, 2024, he had the 2 additional cases, and we were unaware when he returned back to Bexar County.
All right, so correct me if I'm wrong. My understanding is he was deported
Correct, Your Honor.
and he came back to the United States.
Correct, Your Honor.
And I'm assuming, if I'm wrong, correct me, that he came back illegally.
Correct, Your Honor.
And then he came back and committed a new offense.
Correct, Your Honor.
And I understand driving without a license or with an invalid license. I understand we're not in felony territory.
Correct, Your Honor.
All right, this is what the court is going to do. The court is going to find you guilty and find 13 true. The court is going to sentence you to 8 years in the prison, give you credit for any time served, and there's to be no re-entry into the United States. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes.
All right, you do have a limited right to appeal. If that right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand?
Yes.
All right, do not come back unless you're back legally. You understand?
Yes, ma'am.
All right, good luck to you.
May I be excused, Judge?
Yes.
Thank you.